Except for respondent 15, 25, 46, 47, 48, 44 and
Respondent
57.
15,
25, 44, 46, 47, 48 and 57. We have the passes of 50 people and 7 are not found.
so these are 1, 2, 3, 4, 5, 6, 7 are not found.
Yes, my lord. And
Why not found?
my lord, we cannot trace it out, my lord.
You have to trace it out, madam. And what about the newly implemented?
Newly implemented VCP Bethlehem, my lord, the pass, it has been given to me this morning.
And
This is-
so the Bethlehem we have got. Then
Yes.
what else?
And Mizoram Presbyterian Church,
Ah,
and this is again another VCP Bethlehem. There are 3 passes.
3. There was supposed to be 2. 3.
3 passes, yes, my lord.
Okay. So, for 65 there are 3 passes, correct? And then for PHE, have you got the pass?
PHE is here, it's already done.
You have got the pass.
Yes,
And then for
the school,
the primary school,
my lord, I don't have the pass with me.
I think 65 will be the Presbyterian church, no?
Yes, sir.
Yeah? 65, okay, Presbyterian church also you have got the pass, okay. Now the thing is, another thing, madam,
Yes, my lord.
is, so you don't have the passes for 7.
Your Worship, regarding those 7 people, respondent 44 and 46, their passes have been cancelled.
They have surrendered.
Yes, surrender.
They have
Some-
surrendered.
Yes.
So
Okay,
the
okay, just a minute.
44 and 46 have already been cancelled.
44 and 46. That means 5 passes are required.
Yes. They surrendered their passes, 44 and 46 have been cancelled.
So who is 15? Tang Lian Zawa, Boy Tuama, Tui Tiang. 25 Lalo Tui Tiang. 47 is Khozol. Correct? Then 48 is Mission Veng. 57 is Rinza Dorpui Veng. Okay, having said that, madam, now, first of all, we want photocopies of all these documents to be made. Two photocopies. Number 3, and then the next thing is that we want all the connected papers of all these documents, all the connected documents, to show whether the authority who gave these passes or who approved these passes are the competent authority. Because these could be all fabricated also. We want to know who has. Now, so we want to know we want to have all the connected papers. Number 2. Number 3, we want the person who approved, designation and name, approved the issuance of these passes. And number 4, we want to know on what basis these passes were issued. Is it a pick and choose? He's a handsome fellow. And this one is a fat fellow also. What is the basis for giving this passes? You see, there has to be some guidelines for giving a particular plot of land. Everyone wants, even I want, you give me also, I will take. I think even you want, even Mr. Malhotra wants, everyone wants. He'll make another Malzo there. So we all want. So we want to know the basis for giving these passes. They cannot, pick and choose as you like. So, photocopies of all the passes that you have.
Okay.
And the connected papers of these passes. Number 3, the person, the designation and name of the person who gave those passes. Yes, approval. And no possession to be given to any of these pass holders, because it's anyway not in their possession. This is Assam Rifles land for the time being. And you cannot also give away any portion of the land to anybody. Okay. The problem is, if everything was there, then once these things are done, because we do not know, once we give back all your documents, it might disappear. So that's why we are asking for photocopies. Okay. And please have it paginated make it into a paper book kind of a thing.
Yes.
Okay, all the documents.
All right.
You can make, the paper book don't have to be this thick. You can make it into 2, 3, 4,
Yes, yes.
5 books.
Volumes.
The volume 1, 2, 3, 4, 5. So it's easy to turn the pages. Okay. At least we are getting somewhere now. At least the documents are there.
One extra copy we made for the petition also.
We'll give you make and then let them pay for it. They've got enough money. Even the others might want.
Yes.
4 sets maybe.
4 sets altogether. 4 sets.
One for you.
You'll also want one.
Yes, madam.
You'll also want one. Okay, right. Make it 4, 5 sets. 5 sets, I think. Right. These 2 cases pertain to the validity of the land passes issued to the private respondents in WPC (PIL) number 31 of 2020 and to the writ petitioners in WPC 13 of 2020. Which apparently overlap the Assam Rifles land vacated by them. In the year, when did they vacate the land?
Last year.
No. Long time back. Vacated by them. Full stop. It is an undisputed fact that the government of Assam had made a boundary description of the land of the Assam Rifles in the official gazette in the year 1952. It is also not in dispute that except for the deceased respondent, the descendants of the deceased respondent number 49, in WPC PIL number 31 of 2020. No other landholder has filed any claim before any other court prior to the above cases. Correct? I don't think you have filed any case. You have not filed, no? Full stop. It is also the issue that's a perusal of the various orders passed by this court would go to show that the issue of whether the land passes were validly issued to the landholders would require scrutiny of the documents pertaining to the allotment of the said lands to the landholders. Full stop. Mrs. Linda L. Fambu, next para, the learned additional AG, submits that the land documents, the official land documents pertaining, the land documents pertaining to all the writ petitions in WPC number 13 of 2020 and WPC PIL number 13 of 2020. No, WPC PIL number 31. This is wrongly placed here. 31 of 2020 have been located, except for the respondents number 15, 25, 44, 46, 47, 48 and 57 in WPC PIL number 31 of 20. Forget that. For 57, first step. Next para. Mr. A.R. Malhotra, learned counsel for the Central YMA, submits that respondent number 44 and 46 have surrendered their passes, their land documents and land, and as such, only the land documents of respondents number 15, 25, 47, 48 and 57 in the PIL have to be now traced out by the department. Full stop. Next para. Considering all the above, we are of the view that the following needs to be done by the state respondents. They are, number one, the state respondents should trace out the remaining land documents of respondents number 15, 25, 47, 48 and 57 in the PIL. Number two, photocopies of all the land documents of the parties that have should be made. Full stop. In fact, 5 sets of photocopies of the land documents should be prepared by the state respondents, wherein 2 sets should be submitted, out of which 2 sets should be submitted to this court. Next para. The Secretary to the Government of Mizoram and Director, Land Revenue and Settlement Department shall trace out all the connected papers relating to the issuance of the land passes to the parties herein. To clarify how those passes came into existence, in as much as the Assam Rifles have been occupying the land, had been apparently occupying the land for more than 100 years. First stop. Next. The Revenue Department shall prepare a list of the officer who gave approval for issuance of the passes of the landholders. The designation and name of the officer should be mentioned in relation to each of the passes issued to the parties. This could clarify whether this may clarify whether the land passes had been issued with the approval of the government. Or whether the same had been done only at the directorate level. The competency of the officer who gave approval for issuance of the passes would also be more or less determined by the said exercise. Next para. The state respondent shall also give the basis and reason for issuance of each of the passes to the individuals mentioned in the present two cases. As state largesse cannot be given in piecemeal and without any parameters or guidelines. The same should be done within a period of
3 weeks.
Today is 23rd. The same should be done within a period of 3 weeks. List the matter on (16) or 17? 16.
My lord, let it come up on 23rd
Why?
next week.
That'll be
It
4
may
weeks.
take time, my lord.
Huh?
It may take time to search out all the.
No, madam, you can do it. You can do it. Otherwise, we'll have to be strict again. Okay, we say within a matter of 4 weeks. List the matter on 23rd. 4 weeks. It is, full stop. Next para. It is made clear that till final adjudication of this matter is made, the vacated Assam Rifles land shall remain in the possession of the state government. And the state government shall not alienate any portion of the land to any individual or organization.
Except
Yes.
in respect of the
Except in so far as it relates to the land which has been decided in WPC number. What is the judgment? WPC number, that OP, that 105 of 2024. The portion of land as specifically mentioned in 105 2024. That the area mentioned in the LSC number so and so. Okay.
because they have been in continuous
I
possession.
know. No, they will continue. Only those persons. They are living there.
Yes.
They are living there.
For orders, item 3.
My lord, item 3, I'll have to seek some more time,
Coming,
my lord.
order, coming up, rock Madam, one thing, you see, this Assam Rifle land thing, what we have asked you to do, please take it up in right earnest. Because there'll be a bench again in February end. And that time we're going to be doubly strict. So it has to be all the requests that we have made. Please tell your officers, please tell your secretary and please tell your director that this has to be taken up in right earnest and on a war footing. Because we cannot, this case, be left in a limbo. You know, some of the documents might not stand up to scrutiny, but some might stand up to scrutiny. Okay.
Yes, madam.
And everything, you cannot leave it hanging. It's a PIL of 2020. It's 2026 now.
Yes, madam.
So next time we come, we'll give only 2 days, and I'm telling you, we're going to be more strict. Okay. Next, yes, item 3, yes.
My lord, in this case, the last direction was to have conduct a spot verification. My lord, there's some miscommunication on our part. If some
How
more time
can
can be granted.
we allow construction in the Aizawl Dutlang Road? It's such a steep place. It's a place where it's got aesthetic value also. People, you want to fill up everyone just for one person's building. You are going to spoil. The atmosphere, the life of thousands and thousands of people of Aizawl. Beauty, everything gone. Then you have got to give water, and they have to throw wastewater. Then they'll have to make a latrine, and then the roads will sink at the end. At the end of the day, after a few years, it will sink. That's guaranteed. Why do they? You cannot. You should not think only, you see, of one individual against the interests of the public. At the end of the day, the public, which number thousands and thousands, is more important than one person's house. Yes, Mr. Malhotra, what do you say? You're for that one person.
In fact, Your Worship, I'm for one, but there are a number of other private respondents also.
Correct. But then how many will there be? Not more than 10, 20.
Your
And
Worship,
at
but-
the end of the day, the entire road is being used by the entire Dutlang, entire Mizoram, entire Aizawl people.
That is why, Your Worship, they have made protected zones.
No.
We are in the unprotected
You see,
zone.
right now, the houses are there till that Haflong area. There's hardly any area left, empty space.
They have made 2 protected zones, and we are the unprotected zone. And we have been given building permit by the AMC.
Every area should be made a protected zone. That direction has to be made.
Your Worship, in that case, then Your Worship, the matter may kindly be heard finally and
Yes,
disposed
yes,
of.
we'll
Otherwise,
dispose of the entire matter now. I don't think we can.
I think the pleading is also complete.
Correct.
So I mean, instead of
We'll close the entire matter. You see, one thing, the problem is everything is now live streaming, so we cannot give the thoughts also very openly. But leaving that aside, you see, every city needs some breathing space. Every city. Mizoram, Aizawl is now a concrete jungle. Earlier people used to walk Dutlang, Bongkon, Dutlang Road, and it was a nice walk. Now so there's only buildings. And they used to see the view. And they used to say, wow. And this is what tourists want. When you go to some other tourist spots, you don't walk along these type of buildings. You see a beautiful spot, you go there, and I'm quite sure it's not between two concrete buildings, that beautiful spot, unless they are into that walking street issue. So, the thing is that in Aizawl, now the only thing is the Chanmari, Chaltlang, there also some houses have come up. This also should be stopped. Miss Linda, Chaltlang to Chanmari, it's still a beautiful place. You see, when the tourists come now in that Koipui area, people are always there taking photographs, always. And what do? Local council and the AMC, they build a toilet there, in the corner. They build a toilet, and you know what they do in the toilet? There is a stall inside the toilet selling momos, pan, and people are buying. And then we stopped it. We stopped it. I mean, it's like you go to Mount Everest, there's a toilet there, right? You don't go to Mount Everest to deposit all your, unwanted thing. You should make it somewhere where it's not, cannot be seen. It should be hidden. And you're putting it in the most important spot where everyone wants to stand, take a photo with the good view behind, and they put a toilet there. And then you go to Chaltlang, the top of the hill, there's a tourist lodge, no one goes and stays there. I mean, it's very illogical. You see, Reyak. Now, this is good because they have not made their tourist lodge on the top of, right at the peak, on that stone. They made it down there, and then people go walk, they stay the night, they see the sunrise. So our thinking has to change. We see a hilltop, very beautiful, I want that hilltop. Let me build a house there. That is, we have to, this thing is for everybody. Everybody should be able to enjoy it. So when you build a house all along that Bongkon to Dutlang Road, what happened? They are all building not one-storied or two-storied houses. They are building 5-6 storied houses. There is not one family who is staying, 5-6 families are staying. And then they need vehicles. Then they have to have garage. But no, they want the road level for a shop. For gari they would stay outside. They'll put it outside. Then the water has to be given, electricity has to be given. So the entire beauty of the place goes. Then you have got to throw the wastewater. Then you have got to make a sock pit for all your unwanted body parts. I mean, it's a waste, body waste. So all these things are, we should have a change in our mindset. I understand you have got. I'm not talking about you you have got a job as a lawyer, no doubt. But you're an AMC, you're the government. You should ensure that these areas the area should be. Just because a person has a LLC doesn't mean that it has to be built up land. Give them LLC, but let there be a notification issued that this is an area where no building can be constructed. And if building is to be constructed, the roof of the building should be at least 10 feet below the road. And let them go down by steps. So that the beauty of the place can be enjoyed by everybody. But no, what they want? They want a house till the road level so that they can build a shop and then give it on rent, make money. For that, let them go down to some, Sarang or something near the railways. I mean, you see now tourism is very important. The world over is tourism. I mean, people have to have the only way they make money, most of the money, besides manufacturing, that's business. but natural beauty is tourism. Mizoram has got nothing. We don't have any industry. We don't even have enough rice to feed ourselves. We have nothing. And now the only thing is that we have got beautiful hills. Now, for a beautiful hill to be enjoyed, you need trees. Not only that, you need a slightly cold climate. No one likes to go to a hot place and stay in the room under AC. So this is what, unfortunately, that's the only thing we have got. We don't have minerals like Meghalaya. We have got nothing. And only in Aizawl, the only two small stretches of land that we have got is this Dutlang to Dutlang Bongkon and Chaltlang Charmari. Otherwise, where else? You have to go out of Aizawl. Just think about it. Now, even this Assam Rifles land, if it's built up, I mean, at least now it's an open space. Thank God. Imagine if it is given to everybody, everybody has houses. Imagine the traffic jam. I mean, it's going to be chaos. I think you should sincerely think of declaring the unbuilt area to be no building should be allowed.
Just a simple prayer. The matter has been lingering since 2024. So if it can be disposed at an early date.
We can. But so you'll be ready. I don't know.
I think
Then,
the
you see,
affidavits are,
because you see these AMC also I don't know what you are doing. You are saying that the slope is angle is what 60 beyond 60%, beyond 60 degrees. Yeah, either your personnel are bribed or they need their eyes fixed. Not possible. You just see this like this. It's not 60%. 60% is like this. You see, because 90, 180. Then round is 360. So, if this is 90, 60 will be like this. That Dutlang hill is not like this. It is like this. We can, if you want, I am willing to go with your officers and have it checked.
since the pleadings are complete, services are all
Okay.
complete.
Right. Counsels for the parties submit that pleadings are complete.
My lord, the last occasion, one thing that I must point out, my lord, last occasion your lordship had passed an order. I'm not sure if your lordship has seen it. Your lordship had directed for a spot verification because people are also constructing sheds and other houses in the restricted area.
So
that's
yes, what has happened to
that
the...
has not
my
been
lord,
done,
That
madam.
is what I was praying before, my lord.
Yeah.
There's some miscommunication in amongst us, my lord. So if some of them can be granted to
For?
conduct spot verification, my lord.
Because it was supposed to be fixed by the respondent number 6, superintendent. my lord.
Order dated?
This was the last court's order, madam.
10/25.
No, that's a major one. I think it's
22/10/25.
Maybe in the main case.
Judge, I mean, yeah. In the meantime, they can conduct the verification also. And on the next
Let us
court
see,
date,
let us see.
this order.
one
16/6.
verification after the other.
16/6, this order.
16.
No, because this case has
No, no,
two aspects.
The link is also.
Okay, right. Ms. Linda L. Fambo, additional AG, submits them. The state government may be given, that the respondent number 6
Yes, my lord.
may be given, how much time?
3 weeks, my lord.
3 weeks time, to comply with the order dated 22/10/2025. And para 14 of the order dated 18/7/2024. The prayer of the learned additional AG is allowed. The respondent number 6 should comply with the said order.
Your Worship, an attempt may be made on the next one.
This is the matter on, you read it.
It's
18
been
February.
lingering since 2024.
It'll carry on till kingdom come maybe.
Then, Your Worship, at least my application may be considered the next court date.
We'll consider, there's no hurry. It's just one person's, you build it somewhere else, you've got enough money.
Obliged, my lord.
Yeah, I've taken a loan.
Yeah, you are taking a loan from the money that you've already put in the bank.
For hearing. Item 4.
Obliged.
You'll write the judgment? Huh? 22, I don't know, let's see if it takes too long or not. Hopefully it will not take too long. Yes?
Lordship, this is the criminal appeal, Lordship. Whether your Lordship can accommodate this.
Let us see, it depends on how much time you will take.
All right, Lordship.
How long will you take?
45 to 50, 45 minutes, around 45 minutes.
45, half an hour. Within
hour.
half an hour you should finish. There's nothing here, what is
Yes,
there?
yes, Lordship. And Lordship, I have prepared the a brief which. Also, the brief facts of the case.
Where was the drug seized?
Drug seized at the residence of the appellant, Your Lordship.
Residence of the appellant.
Appellant, Lordship.
Between what time? What time?
Lordship, time
Give us
is at
NTPS,
around
sir.
3 p.m.
3 p.m.
Lordship, yes.
So will section 42 apply?
Lordship, there is no evidence to show that that has been sent to the superior officer also.
Mr. Counsel, one thing at a time. Now, what is wrong with the seizure of the articles, drugs in the house of the appellant? What is wrong?
Lordship, at the time when the contraband item was seized, the appellant was not at Champhai, Lordship. He was at Aizawl.
But it was in your house.
It was in my house, Your Lordship. That was not denied. And it was seized from the.
So there is nothing wrong with the seizure.
There is nothing wrong with the seizure in that sense, Your Lordship, but that the prosecution had relied upon the confessional statement, alleged confessional statement.
No, that is all right. Confession statement is a different thing. Basically, the seizure, there is nothing wrong with the seizure. Correct? Just because you are somewhere else doesn't mean that the contraband cannot be taken, cannot be seized. There was an information received by him, the police officer.
Lordship, yes.
He has taken it down in writing.
Down in writing, Lordship, yes.
He has submitted to his superior officer.
No, Lordship, that evidence is not available. That is one of my points.
No, but did you question in your cross-examination the witness? Did you send it to your superior officer? Did
Lordship,
you?
yes, that was available.
Now what did
He said that.
what
there
did he
is-
say?
He said that at page. Page 25, Your Lordship. That is the cross-examination of the case IO. Page
25, yes.
Your Lordship. Paragraph number 2.
Yes.
I agree that in the documents such as grounds of belief and the information in writing, there is no signature
okay,
of the
but they were
OC.
delivered to OC.
However, they were delivered through OC as always.
Correct.
But also there is no paper documents or documentary evidence to show that it has been sent to the superior officer, Lordship.
When they have said it, what do you want?
Lordship,
Videograph?
at least they have to acknowledge that.
Where is the
they
law
have
on that,
received.
Shwas? That they have to have signed? Where is the law which says that once it is sent to the superior officer has to sign that information which is taken down in writing?
But
Where is
Lordship, at this, regarding that, there is some
You
citation.
see, it only says here, within 72 hours, send a copy thereof to his immediate official superior. That's what he has to send it.
Immediate superior.
But Lordship, there is no document to show that it has been sent to the superior officer.
He has said it, Mr. Counsel, he has said it. There doesn't have to be a document.
At least that has to be in the, Lordship, in the evidence, stating that I have received the information or the information or grounds of belief.
Show us the law.
May take Lordship to 2000.
And another thing, Mr. Counsel, the question of
yes.
grounds of belief does not apply when the seizure has been made at 3 o'clock. It is prior to sunset.
And Lordship, that information about the arrest and the that has to be forwarded to the superior officer, which is 42(2) of the NDNPS Act, which is mandatory, Lordship.
Yes.
Then,
Then what
Lordship,
else?
Lordship, may I start from the serial number 1?
Yes, yes.
Yes. May take Lordship to page 1, which is the FIR, Lordship. Page 1. May I
Yes.
read, Lordship?
No, you see, that way we are going to take forever. The thing is that,
Yes.
was the samples taken in the presence of the magistrate?
Yes, that was done, Your Lordship. But
was
actually,
done.
Lordship, there is a,
So 52A compliant.
Lordship, in this regard, there is a standing order along with the Supreme Court order. May take Lordship to the standing order. One of 1989.
So 52A compliant, yes.
Seems so.
That's what he said. That's what he said.
Sample taken from HP.
Lordship, this is the standing order at that relevant time. May take Lordship to Section 2, General Procedure for Sampling, Storage, etc. (2.1), Lordship. 2.1, Lordship. All drugs shall be properly classified, carefully weighed and sampled on the spot of the seizure. Lordship, it is very clear that sample has to be taken at the spot, and that was not done, and that was not denied by the seizing officer.
And what has the Supreme Court now said?
And Lordship, besides that, there is a 2023 19 SCC 2023 19 SCC 364 para 8.
It is here. Yeah. Yes.
May I read, Lordship?
Paragraph.
Paragraph number 8. Lordship, got it? Page 370, paragraph 8. May I read, Lordships?
Yes, yes.
To be noted, the aforesaid notification, which was in existence at the time of the commission of the offence, alleged in the case on hand stood repealed with effect from such and such notification such and such. In any case, a notification issued in derogation of the powers conferred under subsection 1 of section 52A of the NDNPS Act can never contradict the main provision, particularly subsection 2. However, any guidelines issued by way of notification in consonance with section 52A.
So, Mr.
has to be-
Counsel, the simple issue is this.
Lordship, yes.
Have these guidelines been issued in consonance with 52 on the basis of 52A?
Lordship, yes, as per my understanding.
Where does it say that? Where does it say that this guideline has been issued in consonance with 52A? That is what the judgment says.
Lordship,
Where does it
Lordship,
say
here it says that that notification 23/12/2022 GSR number 89EE, that is also the next notification. Next means, Lordship, after this one of 1989 that has been issued, Lordship. So it has to be, goes together, Lordship. So this notification along with 52A of the NDNPS Act has to be followed mandatorily. And Your Lordship, there is a discrepancies because, Your Lordship, there is a reasonable doubt that it is not known that the sample which is brought before the magistrate and the seized article were same, Your Lordship. Because normally at the time
Where
of
is your cross-examination to that effect?
that is on page 25, Your Lordship.
Yes?
Cross-examination, may I read, Lordship? It is a fact that I visited the PO along with the seizing officer in my capacity as IO. I agree that in the documents such as grounds of belief and the information in writing where there is no signature of the OC concerned, however, they were delivered to OC as always. It is a fact that the tablets were particularly counted and we rounded up the numbers as we are well aware of the contents of each bundles, sub-bundles and package, and each bundles and as sub-bundles are in consonance with each other. To be specific, all the bundles, sub-bundles and small packages are separately counted. However, we did not count the number of tablets except from one packet. It is a fact that we seized 11 bundles and we submitted 11 exhibits to FSL as sample. It is a fact that we were not equipped with UN field testing kit during that time. That has to be a test memo at the time of the seize. It is a fact that the seized articles consist of red color and spotted with light green colors, and rarely there were tablets that resemble purple color. It is a fact that the samples sent to FSL were not only red color, I also sent green colored tablets. It is a fact that I was present at the time of sampling. In fact, the magistrate came to the police station as requested and samples were drawn at the police station in front of magistrate. It is a fact that I deposited the seized articles as soon as finishing drawing of samples, and they were briefly entered and recorded in the Malkhana registered book. However, no receipt nor copy of the exact of the said registered has been submitted. Lordship, at this stage also, this juncture, the case IO had stated that he had deposited the samples to the Malkhana, but it is not the job of the case IO. As per this notification, that standing order, it is the duty of the seizing officer to deposit the samples to the Malkhana, Lordship.
According to you, as per this notification, the sampling has to be done at the place of seizure.
Place of seizure, Lordship, and that has to be brought to the judicial magistrate.
But as per the Mohanlal judgment, won't it prevail over this, that sampling has to be done in front of the magistrate who has to certify it?
But, Your Lordship, this inventory was done before the judicial magistrate, but that has to be, as per my understanding, that notification and the this 52A should be in consonance, Your Lordship. And Lordship, here Mal Khana, he stated that no receipt or record proving thus his articulate deposit in the Mal Khana. Lordship, that is also a huge doubt. And next is, it is a fact that I do not know the name of the legal owner of the house from where the seized articles were recovered. However, I know that he has a blood relationship with the rented accused person. I also did not highlight the name of the legal owner of the house, as he has no involvement and as he let out to the accused person. I prepared the charge sheet and I know that all the connected documents are correct. It is a fact that I do not remember all the words spoken by the seizing officer, and I do not know whether body search was conducted or not, but I believe the body search was conducted. Here, Lordship, the seizing officer also stated that that he had deposited the samples to the Mal Khana, which is also again in violation of the this standing order 3.4, which I have already given to your Lordships, 3.4 of the standing order. No, 3.3, start from 3.3, Lordship.
This is a guideline made by the government. Will it override a Supreme Court order?
Lordship, here the Bharat Ambala case had stated that, Lordship, mere non-compliance of the procedure under 52A or standing order thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence, rendering the prosecution case doubtful. Here it says that mere non-compliance, but it is not a mere non-compliance, but it throws the this reasonable doubt, Your Lordship.
Mere non-compliance, it means non-compliance. Whether it is mere or deliberate, it is still non-compliance.
Lordship,
Then,
as per my understanding, it is not, this is a total non-compliance, It is not a mere non-compliance. Because of the fact, this non-compliance of this standing order, then the prosecution case is very doubtful. Here, Lordship, the standing order 3.3.
how much
says
was,
that,
what was recovered? How much drugs was recovered?
14 14.228 kgs.
14.228 kgs
Lordship, yes.
of
Methamphetamine.
methamphetamine.
Lordship, yes.
Worth how much in the market?
165 lakhs.
165 lakhs.
Lakhs, Lordship, yes.
1.65 crore.
Lordship, yes.
It was found in your house.
It's found in the
14
house
kgs.
from the skirting of my house, Lordship. And I have no knowledge of that. Because there is no evidence to show that this is my this is my position, or that has been kept without. I don't have any conscious position at all, Lordship. So there is no evidence at all. And the only evidence the prosecution is relying upon is that the confessional statement made before the CID ISO. But that was not done also, Lordship. And here the FIR had clearly stated that, I take Lordship to page 1.
You probably saw them coming from far and ran away. Where is this? Where was it? Where is the house? In which area?
House is at Champai, Lordship.
Oh. Where is the border town?
Yeah.
Okay, carry on.
Oh, Lordship, this is the FIR, may I read, Lordship? The FIR clearly reveals how it happened, Lordship. Which is at page 1. Page 1. On date, Lordship, on date 1/6/2019, at around 3 p.m., information received from a reliable source that some narcotic contraband substance suspected to be methamphetamine is kept at the residence of Hau Kan Kem, who is the appellant, of Beng Thar Champhai. Accordingly, self and party comprising Champhai PS staff and CID SB Champhai rushed to the residence of the above mentioned person. On checking of the said house, we recovered 11 bundles and each bundles containing 50 packets valued of 165 lakhs approximately in local market of red tablets suspected to be methamphetamine, which was concealed inside the lining of the skirting of the house. The recovered items were seized from the possession of Chin Sian Ding, wife of Hau Kan Kem. The seized items were packed and sealed in the presence of two reliable witnesses. Lordship, it has been recovered from Chin Sian Ding, who is my wife, Lordship.
Oh,
That
Okay.
Chin Sian Ding,
Skirting of the house.
skirting of the house. But it says that the recovered
Inside the
items were
house.
seized from inside
inside the house.
inside the house.
And
That
recovered from your wife.
recovered from my wife, as per this FIR.
Then what happened to your wife? What-
Lordship,
What happened to her? Was she made an accused?
she made an accused, Lordship.
Then
She was acquitted
by the court.
by the court. Actually, Lordship, at that time, my wife was heavily pregnant, about to deliver. So then they
okay,
asked the whereabout of myself, Lordship.
So,
The
so
total,
because she was pregnant, they had sympathy for her.
yeah, maybe that's why. Because at that time it's around 8 months pregnant. And the total weight of the seized item is 14.22 kgs. The other accused person, here, Lordship, the relevant is, the other accused person, head of the family, Hau Kan Kem, presently stay at Aizawl, and CID Aizawl are requested to locate and apprehend him from the spot. So, the CID SB Aizawl reported that he was apprehended at Aizawl today itself. The seized articles were brought to you after observing all legal formalities at the spot. Also here it says that the seized articles were recovered from my house, and after recovery of the seized article, then the Champhai police requested the CID Aizawl to locate the present appellant, Your Lordship. But the statement was Your Lordship, the statement was changed by the seizing officer. But the seizing officer says that the seized article were recovered based on the confessional statement made by me before the CID Aizawl, Your Lordship. So there is a
So this skirting is besides the master bed,
master bed as per this
in your bedroom basically.
bedroom, Lordship. And I have 2 children also. And my wife is heavily pregnant.
And what do you do otherwise? What work do you do?
Lordship, I'm a daily laborer.
Daily laborer.
Lordship, yes.
Daily laborer, you've got a car also. Huh?
Lordship,
No, you've got a car or not?
no, I don't think so, Lordship.
You don't think so?
I have no knowledge of that. And Lordship, it is very clear that because of the sympathy of my wife, and though I was innocent and I was traced at Aizawl and I was brought before the Champhai court and I was convicted. Since I have no knowledge and there is no evidence to show that I have a knowledge of these contraband items which was recovered from my house. So there is a made-up story, Your Lordship. And Your Lordship, the seizing officer had deposed before the court that based on my confessional statement, the SA was recovered from my house. But here it clearly indicates that the SA was already recovered when I was apprehended by the CID.
Look at your answer
CBS.
to the 313 is question at page 91. Page 91. This is page 90. Just look at page 90. Page 90. Page 90. His thing starts from here. Okay, failure given by accused, how can this happen? This is different, top part is different. Then you come to page 91. So this question number 2,
Lordship.
you have not denied that it was kept at your residence.
Page 92. The evidence against you is that on 14.2 cases of methamphetamine was recovered from your residence. They have, but Your Lordship, I have came to know that it was recovered from my house. So I cannot deny that. Because it was kept in my residence. That is a fact. Because they have recovered.
Who has kept it? Some unknown fellow has kept it.
I don't know, Your Lordship, because during that time also I was at Aizawl.
If 20 crores was put in your house, you won't know also. And out here he's put 165 lakhs worth of drugs, 14 kgs, and you've got no idea.
The only things which I...
Next time tell them to put money, not those unknown persons.
And Lordship, even in the T1T also, I was not asked whether I am going to have defense evidence or not. It's only simple 4 questions.
No, did you tell the court that you wanted to have defense evidence? You want to have defense evidence?
It was silent, Your Lordship.
No, do you want to have defense evidence? We'll send it back, we'll remand it back, we have defense
Yes,
evidence.
Lordship, I want the defense evidence because I have to defend myself, Lordship.
Where is your prayer?
And the other relevant from the impugned judgments and sentences, Lordship, at page 105.
Look, this is basically a discovery of the thing on the basis of your confession.
Yes, this is the prosecution had stated that based on my confessional statement, it has been recovered. But Your Lordship,
And
the
what
FIR had
did the witnesses say? What did the Caesar witnesses say with
Also,
regard to
yes.
this?
Caesar witness says that based on my confessional statement, it was recovered. But he is the person who had received, who had filed the FIR, Lordship, the seizing officer. And the seizing officer himself in the FIR had stated that it's already recovered at the time when I was apprehended at Aizawl. So it's completely contradictory to each other, Lordship. The thing is, Lordship, that this article was recovered from my residence, and my wife was pregnant at the time and about to deliver, and the prosecution asks about the whereabouts of myself. Then, since I was not at my residence, I was at Aizawl. I was apprehended at Aizawl. So they make up a story, Lordship.
Who was the seizing officer?
Seizing officer is PC Lian Siam Puyi.
No, we don't want to know the name, designation.
SDPO.
SDPO, subdivisional police officer. So he's a class 1 officer,
Class 1 officer.
gazetted.
In total, 7 witnesses were
7 witnesses, Your Lordship. There are 7 witnesses.
Forensic person was examined.
Lordship, forensic officer. Page 21, Your Lordship. Page 21.
Got it. Thank you.
And this here, the sample which they have collected is under 1 gram. Sample also. Which is less than 1 gram. And besides that, Lordship, there is no receipt nor record proving that the seized article were deposited in the Malkhana. That's my grounds number 2, Lordship. And no sample of seal was sent to FSL for the purpose of comparing the seal appearing in the sample parcel, which is mandatory as per the Apex Code, Your Lordship. May take Lordship to 2005 TSCC, 2005 TSCC, page 59, paragraph number 3.
You have given in the chart this one.
Lordship, yes, already submitted. 2005 TSCC, page 59, and the operative is at paragraph number 3. May I read, Lordship? Paragraph number 3. We have perused the judgment of the High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactorily. In the first instance, though the seized articles are said to have been kept in the Malkhana on such and such, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by the PW number 6 on 5/6/1995. We further find that no sample of seal was sent along with the sample to the excise laboratory, Jodhpur, for the purpose of comparing with the seal appearing on the sample bottles. Therefore, there is no evidence to prove satisfactorily that the seals found were in fact the same seal as were put on the same bottles immediately after seizure of the contrabands. These loopholes in the prosecution case have led the High Court to acquit the respondent. Here in my case also, the seizing officer had stated that he had deposited the seized article to the Malkhana, but there is no Malkhana registered.
Did you question the officer to the effect that it was not deposited in the Malkhana?
Lordship,
Did you say that what he had stated in his evidence was a lie? Did you question him on that? Look, if you do not question an officer, if you accept what he says as true, how can you later on say that he has to produce this and that, unless you deny and say that what he has said is false, then he will produce. He might have it in his possession also, we do not know.
Lordship, we have asked that questions, which is
Where
which
is
I've
that?
already read out at page number 25.
25, where?
25.
Where have you asked him?
Malkhana registered book. Yes, I have asked, Lordship.
It is the fact that I deposited the seized articles as soon as finishing drawing of samples, and they are briefly entered and recorded in the Malkhana register book. Now, if you want, we can call him for that now also. It's a continuation of the trial, first appeal. So we'll ask them if they have it, please produce.
Lordship. Or Lordship, it may be remanded back before the trial court, Lordship. Since my wife and my minor children are suffering because of I was in the custody, Lordship. Since I have no involvement.
You look at this. There is 165 lakhs worth of drugs in your bedroom. And you do not know how it ended up there.
2013 SCC online, Uttarakhand. This is the Lordship Uttarakhand High Court. Also, page 3, paragraph number 2. Page 3, paragraph number 2. Honorable Apex Court, in the case of such and such, in paragraph number 3, has held as under. We have perused the judgment of the High Court.
Where? How does it start?
Lordship, Honorable Apex Court, in the case of.
In the case of State of in the middle.
Yes, Lordship. In paragraph 3 has held as under. We have perused the judgment of the High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactorily. In the first instance, though the seized articles are said to have been kept in the Malkhana such and such, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW number 6 on such and such. We further find that no samples of the seal was sent along with the sample to the excise laboratory, Jaipur, for the purpose of comparing with the seal appearing on the sample bottle. Therefore, there is no evidence to prove satisfactorily that the seal found were in fact the same seal as were put on the same bottles immediately after seizure of the contrabands. These loopholes in the prosecution case have led the High Court to acquit the respondent. In view of the dictum of the Apex Court in the case of Gurmal Singh Supra, sample seal and Malkhana registered are most important link evidence, and in the absence of important link evidence, prosecution story becomes highly doubtful. PW number 1 such and such and PW number 2 on oath that information to the superior officer were sent to telephone on itself about the arrest of the appellant and seizure of the contrabands. While seizure memo Exhibit A3 contains that information about the arrest of the appellant and seizure of the contraband would be sent to the superior officer by telephone as well as through proper channel. There is absolutely no paper on record to suggest that information about the arrest of the appellant and seizure of contraband from the appellant was ever sent to the superior officers as required under Section 57 of the NDNPS Act. Lordship, here in my case also, besides the Malkhana registered book, there is absolute no paper on record to suggest that information about the arrest was not sent to the superior officer, Lordship. There is no evidence at all, Lordship. So that makes the a prosecution case very doubtful, and the benefit of doubt was given in this case also, Lordship. And Lordship, another 2023 SCC Guwahati 2760. Page 63 and paragraph number 63 and 69 also. Paragraph number 63 and 69. May I read, Lordship? Further, the learned counsel for the appellants laid stress in her argument that Section 57 of the Act requires an officer to report within 48 hours of every arrest and seizure to his immediate superior officer, giving the details and particulars of such arrest or seizure to his immediate official superior right from the time of receiving the information of the possession of contrabands and thereafter the progress made at each stage so as to ensure against fabrication of the police case. In the instant case, there is no evidence that the provision of Section 57 of the Act has been complied with. This adds to the list of discrepancies in the prosecution. So in my case also, there is no evidence to show that it has been sent to the superior officer within 48 hours.
Read the next paragraph.
64, it has been observed in such and such supra. It is true that provision of Section 52 and 57 are directory. Violation of these provisions could not ipso facto violate the trial or conviction. However, the IO cannot totally ignore these provisions, and such failure will have a bearing on the appreciation of evidence regarding the arrest of the accused of the seizure of the provisions.
So it's mandatory, is it?
Directory, Lordship, yes. And also may take Lordship to page, paragraph number 69. 69 of this judgment. In the instant case too, there is not a whisper in the evidence in what manner the samples were kept safely. Malkhana registered was also not exhibited to prove the fact that the samples were kept in safe custody.
But here there is a whisper.
But the
In
whisper
page
is,
20 no, in this case there was no whisper. But here there is a whisper.
but the whisper is very doubtful, saying that I have
Whatever it
submitted
is,
without any supporting
No,
documents.
agreed. Okay, whether it's doubtful or not, we're not on that. There is a whisper.
The whisper is that much only,
So-
Lordship.
so-
Yeah, that much only. And your Lordship, the case IO claimed that he had deposited the SA to the Malkhana, but this is against the standing order.
Your time limit is coming up.
Because 3.3 says that it is the duty of the seizing officer to deposit the seized article to the Malkhana, but not the job of the case IO, Lordship.
But what prejudice is caused to you?
But your
If
Lordship,
either one of them does it? What prejudice is caused to you?
but your Lordship, that standing order along with the
No,
52A should be...
Mr. Counsel, look, everything cannot be as per standing orders and that sort. The question is, if there has been a violation of some procedure, if there is no prejudice caused to you by that violation, how does it change the nature of the case? You have to convince us that violation has caused prejudice to you.
But Your Lordship, this the seizing officer is the person who sees on the spot.
So,
And the case IO is the person who was endorsed to investigate the case. So there is a gap between that. The seizing officer, after doing the
so tell us the
formalities,
difference.
has to be kept into the
How
mouth.
how does it become illegal if someone else does it? How does the act become illegal if instead of A, B does it? You show us that illegality.
And Your Lordship, the circumstantial evidence is break somewhere in this regard, Your Lordship. So this is a very stringent law, Your Lordship. Then the prosecution has to prove beyond reasonable doubt. So there is a reasonable doubt, because the seizing officer sees on the spot and doing the formalities, it was endorsed to the case IO, and the case IO had deposited to the Malkhana. This is very doubtful because that chain was break.
And what about the presumption of guilt under section 35?
Lordship, yes, understand. But at that time also, I was not there, though it was inside my bedroom. My wife was there, and I am innocent. I was at Aizawl. I do not have any idea at all, Lordship. And because of that made-up story, I was convicted.
That is not made up. You have admitted in a 313.
No, Lordship, what
you
I had
have,
admitted
you have
was...
admitted that it was there in your house, but you did
Yes.
not know who put it.
Yes, yes. Because that was a fact. That
So what does 106 of the Evidence Act say?
But what I had
When
admitted
some
was it
offence
has
is
recovered.
committed in the secrecy of the four walls of your house,
But Your Lordship, there may discover something in my house also, which I do not have knowledge at all. That then conviction against me is injustice, Your Lordship.
14 kgs of drugs will be what, this big a packet or
No.
this big?
Lordship, at that point of time, I was not there.
Maybe
There
I-
may be someone which I do not know, Your Lordship. I am not able to answer before the law court also, because I am not aware of that at all, Your Lordship.
Yes,
And,
anything else?
and my next point is, Your Lordship, regarding the disparity between the time of the alleged confession made by me and the time of recovery of the SA, which I have already submitted before Your Lordships, that as per the FIR and the report of seizure, Lordship, report of seizure and arrest, which is at page 37, Lordship, page 37. Report of seizure and arrest, seizing officer had submitted. May I read, Lordship? As per provision of section 57 of the NDNPS, I am submitting here such and such. I beg to state that on 1/6/2019 at around 3 p.m. we recovered 11 bundles, each contained 10 packets suspected to be methamphetamine from the residence of Hau Khan Kem, which was concealed inside the lining of the skirting. The recovered items were seized, packed and sealed in the presence of the reliable witnesses. The total weight of the item is 14.228 kgs. Value is such and such. The accused person, this is appellant, presently stayed at Aizawl, and CID SB Aizawl are requested to locate and apprehend him from the spot, which clearly indicates that the seized article was already recovered when the Champhai police had requested the CID Aizawl to locate and apprehend me. So that disparity also makes very doubtful, Your Lordship. And in support of my submission, Your Lordship, I would like to rely upon 1997 1 SCC 272 paragraph 15 and 17. Paragraph 15, which is at page 277. One of the circumstances relied on by the prosecution is that the respondent had confessed his guilt to PW number 6 and PW number 7. In other words, the prosecution relied on the extrajudicial confession of the respondent spoken to by the said two witnesses. In their deposition, they said that on such and such, they buttonholed the respondent and confronted him with certain questions pertaining to the death of the deceased, and then the respondent had blurred out of them of what had happened. The witnesses further deposed that the respondent took out a letter and showed it to them. Witnesses thereupon took him to the police station where the letter was also produced. PW number 14, Sub-Inspector of Police confirmed that these two witnesses brought to the respondent to the police station and produced exhibit such and such. 17, Your Lordship. The aforesaid extrajudicial confession was relied by the trial court, but the High Court did not act on it for two reasons. First is a seeming disparity between the time of making the confession as spoken to by the witnesses and the time mentioned by the police on the strength of the station record. The second record is that the said extrajudicial confession was reduced to writing as Exhibit P7 inside the police station, and hence it is hit by the Section 26 of the Evidence Act 1872. Lordship. Here, this also says that there is a disparity between the time of making confession and then the time mentioned by the police, Your Lordship. In my case also, that confessional statement and the time of the recovery of the seized article are, Lordship, it cannot be matched to each other. There's a disparity, Your Lordship. So it cannot be recovered based on my confessional statement at all.
So how was it recovered from your house in the skirting? There was a hole made in the skirting, in the walls of your house, in the floor. To put in 14 kgs in the skirting, you know what a skirting is, no?
Yes, this.
Side. So there must have been some hole. So you do not know who made the hole.
I do not know, Lordship. And Your Lordship, in this case,
but 14 kgs could fit inside the hole.
Lordship, in this case, there are as many as 4 accused, and the accused number 1 is my accused number 1 is the intended buyer, who is Anand Mizo.
Then
And-
what else? He has been acquitted.
He has been no, he is convicted under 465 of the IPC because he has fabricated the ILP and all. And he is, as per the statement
But
of
he
the
has
other
not been
accused.
convicted under this 29,
No, not 29.
22C.
I was convicted 22C only, not 29
22C.
only.
So he has not been convicted under 22C, correct?
Yes, Lordship. And he is convicted only under 465 of the IPC. And he is also stated that he is an intended buyer, and another person is there who is the respondent number 2 who arranged the transportation of the seized goods.
What happened to him?
He's also he's also acquitted. And I am the only person who was convicted without having any knowledge at all, Lordship. There may be 3 persons who are doing something bad, I'm not sure. But I am innocent. I was staying at Aizawl. I do not know that who kept this as a...
Who
in
kept
my-
14 kgs in your
There
house?
are
And that
other
also
3
in
accused
the,
also, Lordship.
in the skirting of your wall, how did... so that fellow, he must have secretly made a hole in your wall and then put in 14 kgs of drugs.
And Lordship, there are so many...
It's quite plausible, is it? Believable. Do you believe it?
Lordship, I believe That appellant is innocent, Your Lordship. I have spoken to him. He is in the jail.
Is there any hole in your bedroom skirting
That I
where,
do not know, Your
where
Lordship.
14 kgs can fit?
I do not know that, Lordship.
Or is it your case that there is no hole?
That I do not know, Your Lordship.
Anything else?
Lordship, since there are so many benefits of doubt, and it is well settled law that if there two views are possible, and benefit of doubts may goes to the
Accused.
accused, Lordship.
Yes, madam.
May it please Your Lordships. Your Lordship, in the present case, the recovery was made based on the voluntary confession of the accused. And Your Lordship, what the council has stated that is that the FIR and the evidence of the seizure witness, the seizing officer. Your Lordship, if I may take you to the statement of the seizing officer that is in page 13, it is very clear in this.
1-3.
1-3. If I may read out.
Yes.
I know the accused person. I stood before the court today in my capacity as seizing officer. On 1/6/2019 at 3 p.m., I received reliable information that some narcotic contraband substances suspected to be methamphetamine is kept at the residence of the accused, How Can Kam, at Veng Thar Champhai. In pursuance of the information, I obtained permission from OC Champhai under Section 41, Subclause 2 of NDPS Act, and proceeded to the house of How Can Kam with my parties. After preparing my grounds of belief information in writing and after the arrival of two civilian witnesses, I conducted search at the residence of the accused, How Can Kam, but as the accused, How Can Kam, was at Aizawl at the time of search and only his wife, Jing Xian Ding, was inside the house with her minor children, we could not find anything significant. However, we requested the CID SB Aizawl to locate and apprehend the accused, How Can Kam, and after he was apprehended, he confessed to the CID SB that he had hidden 11 bundles of methamphetamine inside the lining of the skirting beside the master bed. Thereafter, without conducting further search, we broke open the skirting of the house and recovered 11 bundles, each containing 10 packets. One packet contained 200 tablets, which is so-and-so tablet of methamphetamine from the skirting of the house. So, Your Lordship, it is very clear. At first, when they conducted the search, they couldn't find, they couldn't locate. And after, in pursuant with the voluntary confession made by the accused himself, they
To the persons in Aizawl.
Yes,
And they informed you there.
yes.
So he was not there at the time
He
of
was
the
not
search.
there at the time of the seizure. But in pursuant to his voluntary confession,
Which was
The
said here
recovery
in
was
Aizawl. You were informed there in Champhai.
yes,
And then you broke open the skirting and you.
yes, at the time when he made that voluntary confession, he was not arrested yet, he was in detention. So the arrest was made in Champhai. So the FIR was, when she submitted the FIR, she stated that the arrest was made after the recovery. So that is correct. The arrest of the accused was made after the recovery. So in relation to that, Your Lordship, the confession made by the accused, the voluntary statement while in detention, is acceptable as per Section 27 of the Evidence Act, Your Lordship. In that connection, I would like to submit one citation regarding Section 27. 2025-3 SCC 314. Raja Khan. Para number 28. Starting from para 28.
Yes.
Section 25 and 26 of the Evidence Act stipulate that confession made to a police officer is not admissible. However, Section 27 is an exception to Section 25 and 26 and serves as a proviso to both these sections. This court is of the view that Section 27 lifts the ban, though partially, to the admissibility of confessions. The removal of the ban is not of such an extent so as to absolutely undo the object of Section 26. As such, the statement whether confessional or not is allowed to be given in the evidence, but that portion only which distinctly relates to discovery of the fact is admissible. A discovery of a fact includes the object found, the place from which it is produced, and the knowledge of the appellant accused as to its existence. And in paragraph 30, the essential ingredients of Section 27 of the Evidence Act are thereof. The information given by the accused must lead to the discovery of the facts, which is the direct outcome of such information. So, Your Lordship, in the present case, Section 27 of the Indian Evidence Act purely operates. And since the confessional statement given by the appellant is admissible, and in pursuant to that confession, the recovery was made. So it clearly proves that the accused had a conscious possession of the seized contraband. And once the conscious possession is proved, the Presumption Act under Section 35 and Section 54 of the NDPS clearly operates. And the burden shifts to the accused to relieve himself from that burden, and which the accused fails to demonstrate during his whole trial. And Your Lordship, another thing is that during the whole trial, the accused is present and participated. He even cross-examined all the witnesses at length. And he never raised the objection which the appellant had raised at this stage. So it shows that the objection which he raised is an afterthought and which could not be raised at the appellate stage, and that clearly deserve this appeal application to be dismissed, Your Lordship. And regarding the conscious possession, once the conscious possession is proved, the accused is liable to be convicted based on his conscious possession. Because even in the statement of the prosecution witness, the recovery and the seizing of the article was supported by all the evidence. And the question of that, the question was never raised before the seizing officer regarding that voluntary statement. And regarding the conscious possession, Your Lordship, the counsel has stated that the contraband was not in his physical possession. Conscious possession doesn't mean to have that the appellant has to be in physical possession. It has to mean that he has the knowledge of that contraband. And in that regard, I would like to submit one citation, Your Lordship. 2025 SCC Online, SC 122, Rakesh Kumar Raghuvanshi.
Para?
Para 21. If I may read out.
Yes.
Conscious possession refers to a scenario where an individual not only physically possesses a narcotic drug or psychotropic substances, but is also aware of its presence and nature. In other words, it requires both physical control and mental awareness. This concept has evolved primarily through judicial interpretation, since the term conscious possession is not explicitly defined in the NDPS Act. This court, through various of its decisions, has repeatedly underscored that possession under the NDPS Act should not only be physical but also conscious. conscious possession implies that the person knew that he had the illicit drug or psychotropic substance in his control and has the intent or knowledge of its illegal nature. So, Your Lordship, it is very clear that the appellant had knowledge, the manner in which the contraband was hidden inside the skirting of his residence. In order to take out the contraband, they have to break out the skirting itself. So it is hidden. It doesn't lie just on the floor. So it clearly proves that the appellant had conscious possession and its legal nature. So in that regard, Your Lordship, the trial court has convicted the appellant based on his voluntary confession as well as the conscious possession of the accused. So the trial court did not make any error in convicting the appellant. And the prosecution has able to prove the recovery, conscious possession against the accused. So that this petition, criminal petition, deserve to be rejected.
Appeal criminal.
Yeah. And another thing is that, Your Lordship, since the recovery was made from the residence, the burden lies to the appellant as per Section 106 of the Indian Evidence Act. He had to prove how that contraband has been there, and there is no explanation regarding that. Not even a single explanation was given by the appellant, even during his 313 examination. And not even one question regarding that has been asked to the witnesses to rebut their statement that they seized the contraband from his residence. And regarding the non-compliance, Your Lordship, I would like to submit one citation. 2025 SCC Online SC 110, Bharat Ambale.
SC 110.
110,
Para?
para 50. Para 50 subclose to
50.
50.
50.
Although there is no mandate that the drawing of samples from the seized substance must take place at the time of seizure as held in Mohanlal, yet we are of the opinion that the process of inventory, photographing and drawing samples of the seized substance shall as far as possible take place in the presence of the accused, though the same may not be done at the very spot of seizure. And another thing, I will not read out the whole passage, Your Lordship, I will read out subclause 4. The procedure prescribed by the standing order rules in terms of Section 52 of the NDPS Act is only intended to guide the officers and to see that a fair procedure is adopted by the officer in charge of the investigation. And as such, what is required is substantial compliance of the procedure laid therein. So, Your Lordship, in NDNPS Act, under the NDNPS Act, once the foundational fact is proved, the accused is liable to be convicted. And in this present case, Your Lordship, the foundational fact that the accused had possessed the contraband and the accused had conscious possession is proved beyond reasonable doubt, and the conviction against the appellant. There is no need to interfere with the judgment of the trial court, Your Lordship. That's all, Your Lordship.
Lordship, if I may allow. Lordship, regarding the, my learned friend had read out the statement of the seizing officer. Lordship, the seizing officer deposition was nothing, but this is an afterthought statement, Your Lordship, because the FIR and the report of the seizure and arrest clearly indicates that it was not recovered based on my confessional statement. It was already recovered when the Champhai police had requested the CID Aizawl to locate and apprehend the appellant, Your Lordship. And it was alleged that the confessional statement was made before the CID SB Aizawl, but it is not known to whom, to which person I was confessed. There is no confessional statement before the court also, Your Lordship. So it cannot be rely upon, Your Lordship. So that is the made-up story, Your Lordship. Then this appeal may be allowed.
Your Lordship, only one point. Any evidence made before the court forms a substantive evidence. So even the evidence of the seizure witness, it is admissible because that evidence is taken before the court.
What is the law on the evidence of a police officer? What does the law say? What does the Supreme Court say?
Lordship, here I have the Indian Evidence Act, section 20.
No.
5 and
What does the
26.
Supreme Court say? That is statement of a accused before a witness, before a police. We're not on that. What about the evidence of a police officer? Are we supposed to ignore it? Otherwise, if we are supposed to ignore it, why should he give evidence at all? You don't know. There is a judgment, their judgment, that it has to be considered like any other evidence. Except to the extent that as long as it is not a statement made to a police officer. But with regard to what he sees, what he has done, it should be considered like any other evidence.
And Your Lordship, if suppose that I have made a confessional statement before the police, and that should be in writing, Your Lordship, and that is not available before the court also.
Yes, should the disclosure have been a written disclosure?
Your Lordship, in my humble opinion, there is no mandate that it has to be in
Are you
writing,
sure?
in my opinion.
Your humble opinion may not be that humble.
The things which
Ideally,
matter
it should
is
ideally, it should definitely be in writing. But the question is whether
whether there are recovery
whether
that
it is
leads to a
mandated to be in
recovery or
writing.
not. And what matter is that that confession leads to the recovery of object or not.
But then,
That is-
what does the law say? That's what we're asking you basically. What does the Supreme Court say?
I'm not sure whether it is the mandate or not, Your Lordship.
Anything else? That's all. Any questions? Okay. Heard Mr. John Riel Toto, General Counsel for the appellant, as well as Mrs. Vani Siami, the additional PP. Hearing concluded, judgment reserved.
It's by us.
It'll take some time.
For omission, item 1.
Lordship, course list is not same. In my course list website, number 1 is my case, and
This is KLL Tanpui.
it's not same. It's
Huh?
Bilal Zomliana is item number 1 in the website course list.
This file, oh, अच्छा. So the entire call this is different. Your call this is different from mine.
Yes. Some items.
My God, what happened? In mine it is KLL Tanpui. File is also KLL Tanpui. Okay, anyway, well, Bilal Zomliana is not here. It is not. There is no Bilal Zomliana. You please inform. There's something, some mistake has occurred. What to do? Bilal Zomliana is not here.
And Wednesday, you fixed on Friday, if
It
time
is
permits.
the part 2.
Part 1. Admission.
I don't have any admission.
Here is item number 1, my case.
This is my cause list. I will not show you because I have written notes. Now what to do? Will I just, what? No. But now I have to follow my list. No, I cannot follow your list.
Yes, ma'am.
So let it remain.
We don't
Yes. Oh, but you tell them, okay, that, you see, can you give me your list, your cause list? Yeah. Huh? Can you take it for?
fixed item in the box also.
Okay, even the list, your list and my steno's list is same.
Yes.
My list is different. We are same. You two are same. Okay, you please tell them, what is this? So, but we'll go by my list.
Yes.
Otherwise it will cause
It's
confusion.
written as a fixed item.
It is supposed to be fixed item, yes. It is that compensation matter? No. Compensation. Huh?
Your Lordship, that case will require a full-fledged hearing.
Whatever it is,
Yes, Your Lordship.
it's not in my list, the file is not here also.
Yes, Your Lordship.
Okay, right. Don't write anything, we'll go by my, no. Yes, it's not my causes, huh? And we'll go by my causes. Okay, then let us go. Item 1 is that KLL Tanpui.
Yes, my lord. I filed my reply to the counter affidavit filed by the state respondents. And
So we can list it for hearing?
my lord, the pleadings are in a sense of complete, but the government advocate was supposed to take instructions whether she will represent the directors at MC.
ZMC will also
Respondent number 7.
Yes, Your Lordship. The ZMC will be represented by the state respondents, and we may be requiring at least 3 weeks' time to furnish the paragraphs comments, Your Lordship.
Okay, right. Ms. Laldun resubmits that the respondent number 7, bracket ZMC,
Yes, Your Lordship.
will be represented by the state council,
Government.
state government
Yes,
council.
Your Lordship.
She accordingly plays for 3 weeks' time to file affidavit for respondent number 7. List the matter after 3 weeks.
Much obliged.
Give a date. Give a date. Always give a date.
10 February. Item 2.
Your Lordship, in this matter, I am also appearing on behalf of the state respondents, which is respondent number 6, 7, and also for 5, which is Kala. Your Lordship, in this regard, I have received the pairwise comments on behalf of respondent number 5, which is Kala Siaha.
Okay.
And as to respondent number 6 and 7, I am yet to receive instructions.
Who is 6 and 7?
6 and 7 is, Your Lordship, state respondents. It is
You
land
all have
revenue.
got nothing to say.
Yes, Your
Or
Lordship.
what? Or you all are going to say something?
Your Lordship, I have not received any
No,
instructions. as to-
because you see the issue is, with regard to the compensation given to the petitioner,
Yes, Your Lordship.
he says that his compensation is amount of around 70 lakhs, but he got 35 lakhs.
Yes, Your Lordship.
According to someone, it was due to a
Clerical error.
mathematical
Yes,
clerical error. So whatever be the case, Kala has to submit.
Yes, Your Lordship.
But 6 and 7, what are they going to say? They've got no role to play in the making of the assessment. Have they got?
Your Lordship, no, they do not have as of now, but Your Lordship, if I may be allowed to at least have it in writing from on their
Okay,
behalf.
you take instructions, right. Ms. Lalnun Hui, appearing for the respondent number 5, bracket Kala, submits that. And she needs
At least, Your Lordship, 2 weeks' time may be
2
granted.
weeks' time to file affidavit as parawise comments have been received. She also prays for time to obtain instructions as to whether respondents number 6 and 7 will be filing any affidavit. Next para, right. The matter pertains to the award of compensation to the petitioner. In the award, the petitioner was supposed to be given compensation amount of rupees 70,61,558. However, the same has been reduced to
37, my lord.
37,30,779. Is it? No, I think it's 35.
No, 35 was they first paid him 50%. After that, my lord, there was a revision of the draft award and it got reduced from 70 to 37 something.
Okay, so you have got 37.
So 37 is the final one.
37,30,779. On a query being made, the stand of the respondent number 3 is to the effect that the amount has been reduced due to a clerical miscalculation made on account of the RCC, in account of the building being classified as an RCC building instead of an Assam type building. Full stop. List the matter after 3 weeks.
Obliged.
Much obliged, Your Lordship.
For orders, item 3.
Yeah.
My lord, the IA is for condoning the delay of 8 days. And as directed by this Honorable Court, my lord, I had taken fresh steps upon the sole respondent last week, my lord. So we may await for the service report.
8 days.
Yes.
First step for 8 days. Anyway. Could have taken steps in the appeal itself. Anyway, right. As notice has been issued, as fresh notice has been issued to the respondent White Speed Post on 16/1/2025. This is the matter after 3 weeks.
Obliged.
Item 4.
Actually, there's condonation, 8 days can be condoned. Why
Yes, my
keep
lord.
it
If your
pending?
lordship is inclined, then we can condone the delay.
Then you issue notice in the fresh notice in the appeal.
My lord, my lord.
No point keeping this pending. Oh, did the respondent appear in the trial court?
Yes, my lord.
He appears.
Appear.
Right. No, but anyway, already this order is there.
My lord.
Continue.
Item 4.
Lordship, the IA is for submission of additional documents filed by the applicants, and we have filed our written objection this morning, and we have served a copy to the applicants as well.
You filed an objection. You filed it, or you're going to file it?
Filed it. It's with the registry right now.
So we'll list it.
Yes,
When?
Your Lordship. Next week.
Right. Minister
Jonathan Lawrence.
Jonathan Lalrin Tuanga, appearing for the response number 1 to 3, submits that a written objection to the application under section 40, on the order 41 rule 27.
Yes, Your Lordship.
Bracket 1 bracket B of the CPC has been filed today. List the matter after a week.
Obliged.
But just check up, huh? Just tell them what has happened to this. We are all different cause lists.